Mary apparently filed a motion today pertaining to the lawsuit that I thought we had settled. And Dave, I would love it if you could give us a quick update on what happened today.
I can, Mayor. Late last night, we received word from Tom Lyon, who represented City Council in Ms. Weaver's lawsuit against the city that went to trial last December, phoned me and said that he had received a phone call from Ms. Weaver's new attorneys and that they would be filing a motion to vacate the dismissal of the lawsuit, which was entered and approved by the court last December after we went through half of the trial. As you may recall, we actually went to trial. Ms. Weaver presented her evidence. At the close of Ms. Weaver's evidence, and she was represented by counsel at that time, the city did a motion to dismiss the complaint. While the motion was pending, we had some conversations with the judge, and we eventually reached a disposition where Ms. Weaver voluntarily would dismiss her complaint with prejudice, and the city would not pursue any attorney's fees or costs as a result of the litigation. And there were a couple other stipulations or matters that were addressed at that time, and I think we've provided you, counsel, with those things, more particularly that that counsel would listen to any suggestions that Ms. Weaver had about the procedures, executive session procedures, which were the subject matter of that lawsuit. And also, the other issue was whether or not Mr. Windholt would pursue his ethics complaint that was pending. At that time, we entered into a written stipulation as to the grounds for the dismissal. It was read to the court. The court swore in, I think, Ms. Weaver and Mr. Bester, and they both indicated that the stipulations of dismissal were acceptable, and the court granted the motion and dismissed the lawsuit. Just yesterday afternoon, we received a new pleading from Ms. Weaver's new attorney where she requested that the lawsuit be reopened and that the dismissal be set aside. Mr. Lyons, who represents the city on this case, received it yesterday afternoon about 5:30. He sent it over to me, and I forwarded it on to you. We have 15 days to file a response to that, and we intend to file a response objecting to reopening of the lawsuit. We thought it was over and done, and we think counsel was well aware of the circumstances of the disposition of the lawsuit, and in fact we have performed, the city has performed all of the stipulations that were intended to that dismissal. So we do plan to object to the reopening of the lawsuit, and I will certainly talk to Mr. Lyons about whether or not we should pursue attorney's fees if we have to incur attorney's fees in responding to the motion.
So is this a normal thing that two parties go through a litigation process, agree to settlement terms, and then move forward and do the things to which they agreed, and then one party later says, I actually didn't really like that settlement, I'd like to rescind it?
Is it a normal thing? No, I've never seen anything quite like that.
Okay, thank you. Mary, did you want to maybe offer some words of explanation for why you're asking to revoke the settlement that we all agreed to?
I think it's very plain in the court case that I don't want to rehash it right here.
Okay.
In the pleading, I think if you read it, you'll understand.
Karen?
I really think, for the benefit of the people in the TV audience, that you perhaps need to explain yourself, because we did follow the settlement guidelines, and this was at a cost to the city of close to $67,000 for something that the judge explained to us could have been solved by you having a conversation with your fellow counselors. And again, what you've done here seems to be the same thing that you did before, in that rather than saying to anybody on council or anybody in the city that you're not happy with the settlement the way it is and you'd like to talk about it, instead of it, you just hire a different set of attorneys that doesn't have even the background. So I guess you must have a lot of expendable cash to pay them to revisit all of the all of the tons of information that the first attorneys had to go through, you must have a lot of expendable cash to pay attorneys to go through all that stuff and start all over again with another process. So I think you really owe it to the people that are sitting here and the people at home to explain what it is, because they don't have a copy of this. We all were surprised with it today. So I'd love to hear what you have to say.
Karen, I'd love to sit down on a one-to-one with you. I attempted at one time.
Let's try this, so you can hear, so we can hear.
Jacob, I addressed you one time and said that I would like to talk about this, and I mentioned to you that the judge that time during the court case had said that the reason the city was in court that day was because the city had not been following the law. And I mentioned it to you, that I wanted to discuss it with you, and you said that's not the way I heard it come down, and I believed at that time you didn't want to discuss it.
Okay. Well, I confess to being, I am baffled. Well, first of all, I reached out to you early in the year. I don't want to get into that, but I've reached out to everybody on council and happy to talk to anybody anytime. You and I actually had a meeting that you canceled at the last minute, and I was very clear I was more than happy to reschedule at any time. So that offer still stands. That's true of everybody up here. We have a new councilor. I'll do the same for them as well. This is baffling to me because you sued originally claiming that we needed to do something different with the way we did executive sessions. We went through the lawsuit, spent nearly $70,000 of the public's money on that lawsuit, the end of which we settled and agreed to look at the procedures we followed, something that I would have readily agreed to before you filed the lawsuit had you bothered to bring it up or ask anybody, which you didn't. The first thing you did was file a lawsuit. So $70,000 later, we settled, we agreed to look at those procedures. We did. In fact, we looked at them carefully and made changes. I think were good changes. And now you're arguing that you didn't like the outcome of the lawsuit after all. You'd rather go back and, I don't know what it is you're hoping to accomplish. And we're looking at spending a whole bunch more money now, of the public's money, to deal with a new motion in this a lawsuit that we all thought was over, where again, if you had thought, for example, as you claim here, that we needed to ratify the lawsuit, it would have been very easy for you at any time since this lawsuit was settled for you to bring it up with anybody here. And I suspect that the council would have gladly done whatever additional step you think we needed to do. But again, instead of bringing it up and asking us and suggesting we ratify through some formal process, which I think we would gladly have done, I would certainly gladly have done, the first thing we hear about it is another motion that will result in more legal fees that the taxpayers will pay, money we could spend on things like, say, fixing the roads or other important
Jacob, I think that
needs.
if you remember correctly, Mike told you didn't have to do anything.
I think the city manager was very clear. In fact, the city manager and the city attorney were both very clear about what we had to do. The thing we had to do was, in good faith, consider the process that we use to deal with executive sessions. And we did that. And not only did we do that, we actually made substantive changes to those procedures, which I thought was good. We should ask those kinds of questions about the processes we follow. And if we look at those procedures and decide that we can do them better, we should make those changes. That's fine. The lawyers will fight this out, the taxpayers will pay again, and we'll see where this leads. Karen.
You know, I find this very baffling because we had a study session. We devoted a lot of time to our rules of procedure. We changed our rules of procedure. There were no objections from you at that time, and I kind of liken this to if you don't get to write it the way you want to write it, you're just going to sue us again. And if 5 of us agreed that what we did with changing our rules of procedure, and we thought we were meeting the guidelines of the settlement agreement I spent the whole day in court on December 19th. I was there from the beginning to the end. I read all of the depositions. I was very clear as to what was happening. I do not understand why you would go to the expense